In today's webinar, we'll update you about the overview of the law, the applicability, and key requirements for compliance of the law. Our speaker for the webinar today, C.A. Sanil Varghese, has been with Ibn Hayyan Chartered Accountants for more than 20 years and is a professional with overall experience of more than 35 years in the related field. Please note that this meeting is recorded and there is a Q&A section wherein you could post your questions, which we will try to answer sooner or later. Without any further delay, let us now proceed with the webinar. I now request Sanil sir to take this webinar ahead.
Good morning all. Before we go into the slides, I would like to appraise you regarding how these matters have been compiled for this session. We have looked into the Royal Degree 6 for 2022, as well as the GDPR rules, which is applicable to European Union as well as UK. The laws which are in the making in UAE as well as Saudi Arabia. Okay. Now, we will start the slides now. Hope the slides are visible to all.
Yes, sir, it is visible. You may start.
Yeah. See, as I said, Royal Degree 6/22 promulgating the Personal Data Protection Law was issued on 9th February 2022. This has got 32 articles and it covers around 5 chapters. This law is not actually new to Oman. This portion of law was covered by the Ministry of what you call the Electronic Transaction Law, Chapter 7 of which is replaced by this law. Okay, until 13th February 2023, the old law will be applicable. Henceforth, after 13th of February 2023, the new data protection law will be applicable to Oman. Any law for that matter requires a regulator. The regulator for this law is Ministry of Transport and Communication and Technology. And one more matter which requires the attention of those who are concerned about this law is that the executive regulations for these laws are still awaited. So applicability of the law, it applies to all organizations operating in Oman, as well as all organizations which are outside Oman who are using or collecting personal data of residents or citizens of Oman. The objective, basically, if I say in plain words, you all get junk mails, okay, one day or other. It is basically to control your personal data from being published, sold, as well as it being misused. So the strength of consumer privacy rights and protection, data protection is one of the objectives. Focus on personal data breach, data protection of offices, transfer requirements, data subject rights, all these are covered in this, are the objectives of this regulation. The framework includes the data subject. Data subject is you and me, any natural person who is a resident of Oman, whether he is a citizen or not. Any company using the data or of the resident of Oman, whether the company is registered in Oman or not, fall within the definition of data subject and is the data protection law is applicable to them. As we said, the regulator is the enforcer, which is the Ministry of Transport and Communication. Then we have the key officers or key persons, which is referred many times in this in this webinar, called data controller and data processor, which we will deal with more with the later slides. Definition: any law will have a definition section which defines what is the data, what is a data subject, who is a controller, who is a processor. Directly by their names, ID number, email address. Indirectly, if different sets of data from different sources put together can identify him. Among the personal data itself, we have sensitive data like data, health data, racial origin, sex life, political and religious opinions, criminal convictions, data relating to security measures. What the data protection law deals with is basically mainly the sensitive personal data. So Article 5 of the law states that processing of the above data is allowed only upon obtaining a permit from the ministry. Again, coming to definition, data processing. Processing includes collecting, recording, analyzing, organizing, storing, modifying, amending, retrieving, and transferring. Transferring of data is actually one of the key clauses in this law. As I said, the natural person who is a data subject is a natural person who is identifiable through his personal data. And data controller is also defined under the law. The entity person who determines the purpose and means of processing of personal data and carries out this processing by himself or enters it to someone else. And the data processor is an entity, the entity person who processes the personal data on behalf of the controller. Article 6 prohibits to process personal data of child except with the approval of guardian. Most of the details, what is mentioned in the 32 articles, will be more defined in the executive regulation, which is expected in the coming days. Okay. Article 3 of law states that the provisions of the law do not apply to the processing of personal data carried out for the following purposes. There are many exceptions. Okay, for example, national security, public interest, implementation of units of the administrative apparatus of the state, other public persons of competency, implementation of legal obligation imposed by controller by virtue of law, judgment, or decision, or by court. For example, there are other laws which are prevalent in Oman, which, for example, banks are regulated by electronic transaction law as well as central bank. There are many laws. So if there are laws which are applicable to them, otherwise, those will be applicable, and those laws will override the data protection laws if similar provisions are there in those regulations. Protection of economic and financial interest of the state, protection of vital interest of the data subject, detection or prevention of crime, execution of contract or to which data subject is a party. If processing is within the personal or family sphere for the purpose of historical, statistical, etc., etc. So basically, for the purpose of research or statistical what you call collection of statistics by the state, these provisions will not be applicable. If the data is applicable to the public other ways, if the data is applicable in the public domain, Such data also will not be applicable by these laws. As we said before, the Ministry of Telecommunication and Information Technology is the regulator for this data privacy law. And what are the powers and duties and powers of the ministry is also mentioned in the law. They have to prepare and issue controls, procedures, and processing and protection of personal data, provide guidance and support, receive reports and complaints and decide on them, prepare a register to record controllers and processes, give warnings, order, rectification, and erasure of data, suspend processing of data. So the overall responsibility lies with the ministry. They even have judicial powers to what you call do or take over the equipments or computers and all related matters which are in the possession of the breaches. Articles of rights of the data subject. Article 10 of the law is defining the rights or of the data subjects. These all are governed by certain frameworks which are inherited basically from GDPR as well as other laws. The framework intends for transparency, honesty, and respect of human dignity. That is the basic object of the law. Intent of the law is that. The Oman Personal Data Law Protection Law provides individual with several rights, including right to withdraw consent to data processing. Each individual each company or each organization is supposed to take written consent, clear consent from the data subject before doing the data processing. Right to request correction, updating, or blocking of the personal data. Right to transfer personal data. Right to obtain a copy of the personal data being processed. Right to request erasure of personal data. All these are the rights of the data subject which is defined in the law. Consent. What is consent? Okay, according to the law, it is essential to take a valid consent, and it is stated in the law that the ability of the data, the controller has to prove the consent to the if it is being challenged either by the regulators or by the data subject. It should be clear, specific, unambiguous, is clear affirmative action, and easy right to withdrawal, prominent, concise, separate from other terms and conditions. Consent to include name of organization, name of third parties to whom personal data will be shared, where the personal data is required, how will you use the personal data. Obligations. Obligations of the data controller includes compliance with the Omani personal data protection law, responding to individual rights, enforcing the security measures, managing data breaches, engaging only those processes that are capable of protecting the data effectively. The controller can appoint sub-processes, even maybe it may be outsourced. So he has to ensure that the sub-processes also comply with the law. Obligations of the data controller is stated in Article 14. It includes details of the controller and processor. The controller is supposed to notify the data subject in writing the following: the details of the controller and the processor, the contact details of the data personal data of protection officer. Each of the controller is supposed to appoint a data protection officer as per articles in the royal decree. The process of processing personal data and sources from which it is collected, a comprehensive, accurate description of the processing, its procedures, and the degrees of disclosure, rights of the data subjects, including the rights to access to data, rectify, transport it, and update it. Any other information that may be necessary to fulfill the conditions of processing. Obligations of the data processor, data controller, data processor, data officer, protection officer are the three key persons a company should have to manage and as well as to comply with the law. So a data processor has less autonomy over the data they are processing, but they still may have direct obligations. Okay, if they engage a sub processor, they may be liable to the data controller, and their responsibilities includes compliance with controllers' instructions, enforcing security measures, notifying controllers of personal data breaches. Other obligations. The law requires controllers to appoint, as I said, data protection officer, maintain records, implement controls and procedures to protect personal data, cooperate with ministry, appoint external auditors to verify the compliance with the law. Article 22 states that controllers shall obtain a written consent of the data subject prior to transmitting any advertising or marketing material of commercial nature in the matter determined by the regulation. See, appoint a external auditor is on the request of the ministry or the regulator. It is not to be done in each and every case as we interpret the royal decree. Maybe more guidance or more details of on this will come in the executive regulations. How to comply? The compliance of this law requires more effort, time, and money. Okay, you need to appoint a data protection officer, okay, maintain a personal data register, and record processing of activities. Notify purpose and take explicit consent. Respond with the, when individuals ask about their data. Enforce organizational and technical security mechanism. Notify any data breaches. Manage contractors and update a contract. Protect personal data when transferring outside Oman. Communicate your data protection policies, practices, and processes. The PDPL expressly requests controllers to appoint a DPO. The executive regulations will provide more details on the appointment of DPO and DPO's duty. DPO assists you in monitoring internal compliance with applicable data protection laws, advising you on your protection obligation, providing expert advice, etc. You can assign the role of DPO to an existing employee. Small organization may not have many employees. They could appoint somebody who is suitable as a DPO. Only thing is that he should be independent and expert in data protection, adequately resourced, and must report to the highest management level. Maintain a personal data register. Undertake a data discovery exercise to document what data you hold and process, where it is located, who has access to it. Basically, you have to do a data mapping. Okay, so to complete and which are the data which you hold and that is being regulated by this law. Identify all processing activities, including personal data. Document how and why data is used and what is the processing requirement of processing. Identify and document at least the following for processing activity within your name and contact details of your DPO. Purpose of processing data. Categories of personal data involved. Systems and locations where personal data is processed. Where data is transferred to the list of recipients. Notify consent. That is one of the key requirements of the law. Notify purpose and seek consent. respond when individual ask about their data, that is implement robust procedures to authenticate the requester, and that the response is adequate and timely. The following information is likely to be specified in the response in most of the cases. What personal data is being processed, the purpose and legal ground for processing the personal data, who within the organization has personal data, how long data is to be retained, or at least the criteria used to be to determine this period. How to comply, enforce security mechanism, take appropriate organizational measures such as have adequate policy procedures, business continuity plan, risk assessments, awareness and training. Organization must also take appropriate technical measures as implementing system, physical security, encrypt or anonymize personal data, have robust data disposal measures, secure and reliable passwords and technologies. Notify data breaches. That time frame will be mentioned, I hope, in the executive regulation. In PDPL, the time frame is 72 hours. So similar time frame will be mentioned in the executive regulation. Manage contract to ensure that there are appropriate clauses in the agreement. Conduct a due diligence assessment if there is a sub-processor. Update your existing contract, draft new contracts. Defining responsibilities, liabilities of both parties. Protect personal data when transferring outside Oman. Communicate your data protection policies, practices, and processes. Non-compliance, there are high fines for data transfer running up to 500,000. Okay, and the punishments is up to 1 year for certain other defaults. Other than that, there could be loss of revenue, high litigation, remediation cost. A reputation implication include possible damage to company's brand, loss of consumer trust, loss of employee trust, loss of consumer attrition. Regularity implications, regulator may order to suspend processing of personal data or may order to erase the personal data that are processed in a non-compliant manner. Challenges for compliance includes organizations are not aware of location, nature, and sensitivity of the data. Details assessment to understand personal data landscape, data flow is necessary. Creation of data register. Implement data discovery and data classification tools. Increasing the compliance challenges includes increasing vulnerabilities with current technology usage. Current trends such as below pose a threat to the compliance. Social medias, bring your own device, cloud adaptation, remote work, high volume of data. All these are challenges in implementation of this regulation. Company policies have to adopt to the above, so that then employees has to be trained in this front to comply to the new regulation. Issues, as I said, with the third parties has to be due diligence has to be conducted if there are sub processes. Appropriate data protection processes to be added to the contracts. Periodic risk assessment has to be done. Implementation of proper access controls. Humans are the weakest link, as all you all know. They are the weakest link in a system, so they have to be trained and made aware of these new regulations, and they need to comply with those. Companies needs to ensure the following: regular access reviews, strong authentication tools, removal of or reduction of shared accounts, increase accountability of the employees. Compliance challenges again includes high cost maintenance to maintain this, to build a system which is compliant with the new law, and then maintain the new system with the new technologies will be a cost. The cost is one of the main factors. Increase in documentation and recording is another challenge, which in what do you call in complying with the regulation. Thank you. And if any more questions are there, I can address those. Before I go into the questions, maybe I can talk a little on the GDPR, as well as what are the differences between GDPR as well as the local laws. Local laws is in the line with what is the laws which is being implemented in UAE and Saudi Arabia. There are two differences between the local law and the GDPR, which is applicable to the European Union and UK. Number one, the consent. There is a difference between, for example, if you go out to a meeting and meet a person, you exchange a card. You are visiting card in business card. As per GDPR, there is no compliance if that person is sending you an email regarding one of these product launch. But in Oman, the scene is different. You'll have to take the written consent of the data subject in order to do that. That is one of the key difference. The other one is the legitimate legitimacy is one of the exceptions in GDPR, whereas the legitimacy is not included in the exceptions as per the article in Royal Decree 6/2022. If you look at the legitimacy is applied in GDPR for data collection, direct marketing, employee monitoring for management purpose, employee monitoring for safety, enforcement of legal claim, etc., etc. Legitimacy is one of the roots the many organizations in GDPR in order to uh, apply in order to escape from the data privacy laws. So, any questions are there? Kunal is the one who is supporting me, and Silpa is does the introduction. Let me then thank them upfront.
Thank you, sir.
Any questions? Where is questions? Kunal. Okay. If you have any questions, please post. We will be happy to answer those. Maybe GDPR is one of the laws you are aware of. You are aware of the local laws now. You are the laws are coming up in UAE as well as in Saudi Arabia. I think Qatar as well as Bahrain already has implemented the law. The laws are getting implemented all over the world. For example, in US you have the state laws. You don't have a federal law. Why I am talking about this is that if you are having business dealings with those countries and you are dealing with their data of those residents of those countries, the laws of those countries also will be applicable when you are going to implement this law. If you have already implemented laws, then you will have to look into those jurisdictions in which you fall, and you will have to make a law according to a framework and amend it, or what you call, make amendments to those laws so that you fall into you comply with all the regulations in which you do the business. So you will have to see all the laws which is applicable to you all over the world. When you implement this, there might be, if you are dealing with GDPR, if you are processing their data, if you are doing BPOs over there for them, you will definitely, those laws also will be applicable. Yeah, data, see, you are asking the manual issue. It's not a manual, it's a Royal Decree 6/2022. And it will be followed up by executive regulations, which will be coming up. I have made up these videos based on the laws in existence in UAE as well as the Royal Decree. and the executive regulations are expected somewhere before February 23rd. So we will have to see those things. You'll have to two things you'll have to see. You'll have to see royal degree as well as if you send an email, I can send it. Whoever is handling the data of a data subject is to have a data controller. It is not a tri-party agreement. Data subject is to be had by each of the organization which is having a which is processing the data of a data subject. Mr. Vallavaraj, you could send in, you could type in this. Hacking actually is a crime. Okay, this personal data law is not falling under that. Okay, we have a electronic transaction law in Oman, for example. Okay, this chapter 7 of this law is actually replaced by this data protection law. So hacking will be covered by electronic transaction law or other laws which are existing in the country. It will not be covered by data protection law. It is of a wider range. It's a criminal offense. Yes, you are supposed to, Hardik, you are supposed to ensure that you are talking about a sub processor. You are you have to ensure that sub processor also uh, abide by the legal systems in Oman. That is the glitch. That is the problem. Okay, how when you enter into a cloud contract agreement, you will have to include in the contract all these terms. Data privacies will be adhered to as per the law. That's why you need to, if you have a contract in place, you need to relook into those contracts. If you are entering into a new contract, you will have to include these clauses in the new contract. Hope I have answered it. Yes, Mr. Sudhir, anybody who is handling a data from a data subject is the laws are applicable to them, except for what is exempted as per Article 3. It includes around, it runs from A to J. Okay. If you have a contract with another entity and you have to, in order to execute those contracts, you need the data, you need to process the data, it's exempted. Other than that, okay, basically this law is intended for sending mails to person who did not consent to send mails or other data losses as what you call selling of data without the consent of the data subject. Similar issues, if there is a normal business which falls with a contract with a data subject, then it is out of the purview of data. However, if the contract is over and if the data subject is requesting you to delete the data from the system, the controller has to do that and he has to prove that it is really deleted from the system. questions are there? Yes, Kunal, any more questions?
Is this compliance in place for all companies? Any more?
Yes, it is actually Mr. Sudhir. It is this is actually applicable to all the companies or whose organization who is handling the data of a data subject, unless until it is exempted as per Article 3. Article 3, as usual, runs around, I think, A to J. If you see in Article 3, it is from national security onwards. It ends with the public domain. If the data is available in public domain, those data, this law is not applicable to those. How will you know you need to comply with this law? Okay, if you're handling the data, that means you will have to do a data mapping. What is the data is in your possession? What do you do for marketing? Do your company do a marketing? That is one of the questions. Do you send emails to the in order to canvas business? That is one of the key questions you should be asking, And how do you market your product? What data you already have in your possession? What data of the ex-employees you have in your possessions? All these questions you need to ask yourself in order to answer the question whether it's law is applicable to me. Okay. So law will be applicable to you if you use those data. Okay. If you possess those data, and if the consent is not given to you, and if the data subjects request you to remove the data from your database, and if you don't do those, and if you cannot convince the regulator that you cannot do it or you have not done it, then there is a violation. Then the laws are applicable to you. If the company internally is already doing this, are we supposed to do anything else? The company internally, when they do this, say, for example, the company employee is in US. Company communicates a data from here to a data subject from here to US. It's a clear violation of transfer of data from Oman to US. The fine is up to 500,000. Okay. Even though the employee is of the same organization, we're transferring the data from. So it's not an internal matter. It's a matter of compliance. Of course, the copy of presentation will be available. You will put in the YouTube, and the link can be sent to you. You can see that.
We could also email a copy of presentation to people who had registered with us and who missed the first part of the
Yeah,
webinar.
we can do that. We can do that. Shall we close?
So I
Okay.
hope most of the questions are
Okay.
answered here.
Yeah, you can put the closing remarks, Shilpa. Thank you
Yes.
everybody for their presence and attendance. I hope it was useful to you.
Yes, of course, sir. The presentation was really very informative. I hope the audience also have their queries and questions answered here. And most of them must have benefited, at least when there is not much information available on this yet. So hopefully it has helped them. And for people who have missed the seminar, maybe the first part or maybe anywhere in between, we will share the presentation with you. And there will also be, as Sanil sir said, we'll create a YouTube link so that you can have a run through on the entire session. And first of all, thank you so much for taking time and joining us. Please do let us know if you would like to have more of such webinars and what topics would you be interested. And it will be our pleasure to conduct such webinars and share more information and have KT sessions. So thank you Kunal so much for all the backend support and answering all the questions. And thank you Sanil sir for such an informative presentation. And we thank you all on behalf of Ibn Hayyan Chartered Accountants. Thank you. We're now ending the session.